Imagine a scenario. It's playing out right now across countless industrial belts in India. A massive industrial complex gets its permits, but its waste management system, it fails spectacularly. And suddenly, the local community, people who live, far from the centers of political power, they find their traditional water source is poisoned. The air becomes a hazard to breathe.
Right.
Kids are getting sick. Livelihoods like fishing and farming, they're just gone. So who's supposed to step in? Not just to give out compensation, but to fundamentally stop the violation from happening in the first place. Who defends the right to a decent environment, the right to simply live, when the state or the companies the state has failed to regulate are the ones causing the harm?
That is the exact question. That dramatic, frankly terrifying intersection of governance, industry, and fundamental rights is precisely what we're tackling today. We're moving beyond the theoretical rights that are written down in the Constitution. We're drilling down into the specific statutory infrastructure that was designed to police those rights. Today, we're doing a comprehensive deep dive into the institutional defender of human rights in India, the National Human Rights Commission, or the NHRC.
And welcome back to the deep dive. This is where we take dense, vital material, and today we're drawing very heavily from Laxmikanth's Indian Polity, Chapter 57, and we turn it into actionable strategic knowledge.
That's right.
This is knowledge custom-tailored for you, the ambitious learner, whether you're preparing for the UPSC Civil Services examination or you're just someone who wants a truly granular understanding of how Indian governance actually works or doesn't work.
Our mission today is, well, it's very clear. We're going to dissect the NHRC, its DNA, its legal origins, the really critical structural changes that were introduced by the 2019 amendment.
Which are key.
And most importantly, we're going to connect its practical functioning and its inherent constraints directly to the complex systemic issues that form the backbone of competitive exam questions.
Before we jump into those constitutional trenches, though, just a quick but very heartfelt moment. We'd like to humbly ask you to take just 2 seconds right now to subscribe to the channel.
Please do.
And if you're capable, please consider joining the paid membership on YouTube. Your support is absolutely crucial for us to keep generating this level of detailed, strategic content for your success.
And on that note, we absolutely must give a sincere shout out and a huge thank you to all of our existing members. Your patronage is, well, it's truly invaluable. It helps us sustain this entire operation and ensures that these deep dives remain available and as detailed as they are.
You make this work possible, so thank you. And please hit that like button right now if you find this material useful, and share your valuable comments below. We genuinely rely on your engagement and your feedback.
We do.
And remember, we've got resources waiting for you. Free notes with practice previous year questions, the PYQs, are available on our Telegram channel.
And if you become one of our legend YouTube members, you get access to premium notes, including extra PYQs and model mains answers, all waiting for you on our dedicated Discord channel. So go check them out and keep learning.
All right, let's get into it. Okay, let's unpack this journey. The NHRC is, you said, a statutory creation from 1993. But it doesn't operate in a vacuum, does it? It rests entirely on the bedrock of the Indian Constitution.
Entirely.
And that document is fundamentally different from a constitution that, just evolves over centuries, like the British system.
Yeah.
Ours is an enacted document, deliberately created by the Constituent Assembly.
Precisely. And that's not just a technical point. The Constituent Assembly, which was formed back in 1946, drafted this document with a clear, transformative social mission, the preamble. That's the ultimate statement of intent.
Right. We the people.
Exactly. It commits the nation to securing justice, and it specifies social, economic, and political justice, along with liberty of thought and expression, equality of status and opportunity, and promoting fraternity.
So that whole aspirational blueprint, that's what sets the stage for the entire rights regime.
It creates the moral and legal mandate for anybody like the NHRC to even exist, let alone pursue its goals.
And the immediate mechanism for turning those aspirations into something you can actually enforce in a court of law is Part 3, the fundamental rights.
Yes.
This is the Charter of Must Defend rights. They're primarily seen as negative injunctions against the state, right? Things the state cannot do.
That's the traditional view, yes. But the key to making these rights work is the judiciary, which acts as the ultimate supervisor, the essential sentinel, the watchdog.
The sentinel and the qui vive.
That's the one. The Supreme Court especially takes on this role. Chief Justice Kanya, in that early landmark A.K. Gopalan versus State of Madras case in 1950, he's the one who said the court must be the sentinel on the qui-vive.
Which literally means a guard on high alert.
A guard on the alert. And it's not just some flowery quote. It defines the court's function as the protector of the citizen against potential overreach by the legislative or executive branches. And their primary weapon in this defense is judicial review.
So judicial review is basically the constitutional safety fuse.
Yeah.
If a legislative majority passes a law that strips away core freedoms, the Supreme Court is constitutionally empowered to just strike it down.
It is the ultimate check. And it gives real teeth to these guarantees. I mean, without that judicial enforcement, the fundamental rights would just be, moral pronouncements. They'd be like the DPSP.
Speaking of teeth, let's drill down into Article 21, protection of life and personal liberty. Because this, I think, is where it gets really, really interesting. The Supreme Court didn't just read the word life narrowly, as in, just physical existence.
Not at all. It dramatically expanded its scope over the decades.
Absolutely.
Initially, in that same 1950 A.K. Gopalan case, the court held a very restrictive view. It was mostly focused on procedure established by law.
But that view was completely overhauled.
Fundamentally overhauled, culminating in the transformative Maneka Gandhi versus Union of India case in 1978. That's the big one.
Mm-hmm.
Post-1978, the interpretation moved from requiring a mere procedure to demanding substantive due process.
Which means the procedure itself has to be fair.
Fair, just, and reasonable. The court declared that life includes the right to live with human dignity, which is such a powerful concept. It dramatically expands the state's obligations.
And this expansion is what the NHRC ultimately references in its mandate, right? It brings in this whole cascade of secondary implied rights.
Yes. Can you detail some of the most critical ones? The list is extensive, and it really reflects the needs of a developing society. The court has explicitly integrated the right to livelihood, the right to shelter, the right to health, the right to a speedy trial, all into Article 21.
And going back to my opening scenario, the right to a decent environment.
That is the most powerful expansion, directly addressing issues of industrial pollution and state neglect. And we have specific landmark judgments that make this real, that move it beyond just theory.
Right, like the MC Mehta cases.
Indeed. Think of that whole series of MC Mehta cases in the 80s and 90s. The court used Article 21 to enforce environmental standards, compelling the closure or relocation of hazardous industries in Delhi, establishing the principle of absolute liability for industrial harm.
They even mandated the cleanup of the Ganga.
They did. This judicial activism shows Article 21 functioning as the ultimate constitutional safety net against harm, whether that harm comes from the state or from private actors who are operating with state sanction.
And that's the core of human security. We should also touch on the evolution of the right to privacy, which is now foundational to Article 21.
Oh, that was a momentous legal evolution. Recognizing the right to privacy as a fundamental right in 2017, it affirmed that dignity and autonomy are core elements of life, and that recognition had immediate, profound consequences for governance and individual liberty.
You're talking about cases dealing with personal autonomy and identity.
Precisely. The Navteet Singh Johar case in 2018, which decriminalized aspects of Section 377 of the IPC.
For consensual sexual acts.
Yes. And the Joseph Shine case, which struck down Section 497 on adultery. Both were rooted in this new, expansive interpretation of Article 21. They affirmed the principle that the right to life with dignity includes the right to make personal life choices, free from excessive state intrusion.
And let's not forget the explicit inclusion of the right to free education up to 14 years in Article 21A.
Reinforcing the state's commitment to socioeconomic rights as integral to liberty. Absolutely.
Yeah. Okay, let's move to Articles 23 and 24, the rights against exploitation. These focus specifically on vulnerability, which is a major area for the NHRC's investigations.
A huge area. Article 23 prohibits human trafficking and forced labor, both severe assaults on human dignity. Article 24 prohibits the employment of children in hazardous environments.
And here, again, we see the judiciary not just interpreting the law, but actively stepping in to impose executive responsibility.
You're thinking of the 1996 Supreme Court ruling on child labor.
Exactly. It moved into the realm of mandatory financial accountability.
Yes, the directions related to the Child Labor Rehabilitation Welfare Fund. The Supreme Court didn't just say, don't employ children. It issued a directive. It required any offending employer to deposit a substantial fine, specifically 20,000 rupees, for each child they employed.
And that money went into a dedicated welfare fund.
Yes. It was a clear, active measure forcing the executive and private actors to bear the financial burden of their human rights violations. It shows the Supreme Court acting almost like a super executive when fundamental rights are being systemically violated.
Before we shift to the DPSP, we have to talk about the ultimate constitutional safeguard, especially during a crisis. The history around the inviolability of Article 21 during an emergency is, well, it's critical and it's surprisingly dramatic.
It's probably the darkest chapter in Indian constitutional history.
The habeas corpus case.
The ADM Jabalpur versus Shivkant Shukla case during the 1975 emergency. The Supreme Court's verdict basically suggested that the right to approach the courts for protection of life and liberty under Article 21 could be suspended during an emergency.
Which essentially left citizens with no judicial recourse against arbitrary executive action. A verdict that's widely seen as a failure of judicial nerve.
An intellectual tragedy, yes. But democracy corrected itself. After the emergency ended, Parliament passed the 44th Amendment Act of 1978.
And this is so important.
It is. This amendment explicitly nullified the ADM Jabalpur position. So, post-1978, the enforcement of fundamental rights under Article 21 and Article 20 cannot be suspended by a presidential order, even during a national emergency.
So that's the ultimate affirmation. The right to exist with dignity is non-negotiable.
Non-negotiable even when the nation is at war or facing external aggression.
Okay, that sets the strict, legally enforceable floor, Part 3. Now, let's look at the aspirational ceiling. Part 4, the directive principles of state policy. These are the constitutional goals for creating a welfare state.
DPSP are the soul of the welfare state concept. The idea is to move the country from a colonial-era police state, which was just focused on maintaining order, to a state committed to establishing economic and social democracy.
But they're non-justiciable.
Famously non-justiciable. Article 37 clarifies that while you can't sue the government for failing to implement them, these principles are nonetheless fundamental in the governance of the country.
So it's a moral duty.
A moral and administrative duty on the state to apply them when making laws.
Given that the NHRC deals with violations that often stem from poverty and lack of access, which DPSPs are most relevant to the Commission's work?
Oh, there are direct links to social justice. Article 47, for example. It mandates the duty of the state to raise the level of nutrition, the standard of living, and to improve public health.
That's the constitutional source material for something like the Food Security Act.
Exactly, and it directly relates to a PYQ we'll discuss later. If people are starving, it's not just a violation of Article 21's right to livelihood, but also a failure to achieve the goal of Article 47. Similarly, Article 46 requires the state to promote the educational and economic interests of weaker sections, especially SEs and STs.
But that non-justiciability has always been the biggest criticism. K.T. Shah famously compared them to a check on a bank, payable only when the resources of the bank permit.
He did, and he highlighted the functional limitation. But the framers understood that implementing sweeping socioeconomic reforms like universal health care or comprehensive education requires immense resources and administrative capacity.
Which the new Indian state just didn't have in 1950.
Not at all. Making them immediately justiciable would have led to constant governmental collapse under judicial orders that simply could not be executed.
So the critics kind of missed the point about the practical constraints.
I think they did. The DPSP serves as a moral and political compass. They're the yardstick against which the legislature and the executive's performance must be measured by the electorate. And they guide interpretation, especially in conflicts with fundamental rights.
Which brings us to a complex constitutional nuance. The provisions designed to protect social reforms from legal challenge.
Yes. The framers anticipated that transformative laws like abolishing the zamindari system and other land reforms would be immediately challenged by vested interests, using fundamental rights like Article 14, equality, or Article 19, property.
So to stop these vital socioeconomic reforms from getting blocked in court, Parliament introduced provisions like Article 31A.
It's a critical constitutional shield. Article 31A protects 5 categories of laws, including those for land reform, from being challenged and validated on the ground that they violate fundamental rights under Article 14 or 19.
So the prioritization.
It confirms that while the Constitution defends individual rights, it also prioritizes the state's ability to implement sweeping social restructuring for the greater good. And it's into this huge, complex arena, the gap between guaranteed rights and aspirational goals, that the NHRC has to step.
Which is a perfect transition.
Yeah.
If the Supreme Court provides the constitutional enforcement and the DPSP provide the political mandate, the NHRC provides the specialized, focused, quasi-judicial enforcement mechanism. So let's start by clarifying its institutional identity. This is a common trap for students. Is the NHRC a constitutional body?
No. And what's fascinating here is that distinction. The NHRC is not a constitutional body. A constitutional body, like the National Commission for Scheduled Castes under Article 338, draws its existence and authority directly from the text of the Constitution itself.
So the NHRC is a statutory body. Its authority flows entirely from legislation.
Exactly. The NHRC was established in 1993 under the Protection of Human Rights Act. Its entire mandate, composition, functions. Everything is defined and delimited by that specific act of Parliament.
And that structure is both a strength and a weakness, you said. How so?
Well, the strength is flexibility. Parliament can adapt the institution to evolving needs just by amending the act without the incredibly arduous process of a constitutional amendment.
But the weakness is?
Its powers are ultimately subordinate to the will of the legislature.
And Parliament did adapt it, significantly, in 2019. The Protection of Human Rights Amendment Act. 2019 targeted issues of efficiency and staffing flexibility. These changes are crucial to understand.
Indeed. We need to detail the three most significant structural changes. The first was a change in the term of office for the chairperson and the members.
The term was reduced from 5 years to 3 years.
Yeah.
That sounds a bit counterintuitive for institutional stability.
It might seem so on the surface.
Yeah.
And this change affected both the NHRC and the State Human Rights Commissions, the SHRCs.
Yeah.
The term was reduced to 3 years. But this reduction was paired with the second key change.
Which was?
They were made eligible for reappointment.
Okay, that's the critical counterbalance. So if a chairperson or a member performs well, the executive can offer them continuity.
That's the idea.
But doesn't this ability for reappointment open the door for subtle executive leverage? Couldn't it potentially compromise their impartiality?
That is an excellent and absolutely essential, critical question for any serious aspirant. While continuity is valuable, the prospect of reappointment can indeed be seen as a potential pressure point. It could incentivize members to remain, non-confrontational towards the executive during their first term.
It's a classic institutional design trade-off then. Stability versus strict independence.
It is.
Now, beyond the central body, the amendment also made significant changes to staffing eligibility at the state level. I assume this was to make it easier to fill vacancies in the SHRCs.
It was a very practical change to address capacity issues at the state level. Before 2019, generally, only a person who had been a Chief Justice of a high court was eligible to be appointed as the chairperson of a state human rights commission.
Which is a very small pool of people.
A very small pool. The amendment broadened it considerably. Now, a person who has been a judge of a high court, not necessarily the Chief Justice, is also eligible for the SHRC chairperson post. This is vital given the widespread human rights issues across India that need local monitoring.
And finally, jurisdictional clarity was added for union territories.
Yes, the federal structure demands that clarity. The 2019 amendment empowered the central government to confer human rights functions relating to union territories, with the exception of Delhi, onto the various state human rights commissions.
So it delegates the regional workload.
To existing SHRC infrastructure, yes. Crucially, the functions relating to human rights in the Union Territory of Delhi remain the direct responsibility of the National Human Rights Commission itself.
Which makes sense, given Delhi's status as the national capital.
And a major concentration point for rights issues.
Okay, so we have a statutory body that's constantly being refined.
Yeah.
But the true test of institutional independence that lies in the removal process, can the executive just dismiss a chairperson if they become too inconvenient or critical?
This is a really important question about operational accountability and the security of tenure. The process is designed to be difficult. It's a dual process, providing a judicial safety net that's critical for maintaining the body's perceived independence.
Let's look at the grounds for immediate removal by the president first, the factual, non-subjective grounds.
Right. The president can immediately remove the chairperson or a member on grounds related to clear incapacity or compromised integrity that don't need a complex inquiry.
Like what?
There are 5 grounds. If the person is adjudged an insolvent, if they engage in outside paid employment during their term, if they're unfit due to infirmity of mind or body, if they're declared of unsound mind by a court, or if they are convicted and sentenced to imprisonment for an offense.
So these are straightforward, factual matters.
Exactly. They allow for direct removal. But the critical safeguard comes into play when the removal is based on subjective assessments like misbehavior or incapacity.
This is the cornerstone of the NHRC's independence.
It is. If the president wants to remove the chairperson or a member on the ground of proved misbehavior or incapacity, the process becomes compulsory and involves the highest judiciary. The president must refer the matter to the Supreme Court for an inquiry.
And that referral is mandatory.
Mandatory. And the Supreme Court's role here is advisory, but it's effectively binding, isn't it?
It is functionally binding, yes. The president can only issue the final removal order after the Supreme Court has conducted a thorough inquiry, upholds the cause for removal, and advises that the person should be removed.
So this mechanism ensures that political vendetta or executive discomfort can't lead to the arbitrary dismissal of a human rights commissioner.
Okay, now let's shift gears from structure and law to performance and challenge. This is where we connect the NHRC's mandate to the actual ground realities of Indian governance, which is often what gets tested in competitive exams.
The systemic critique.
Right. We've established this robust statutory body, protected by the Supreme Court's removal inquiry and backed by the huge scope of Article 21. Yet the source material suggests a significant troubling gap exists between the expectation and the reality of the NHRC's functioning.
That is the great paradox of institutional design in India. The internal critique highlights that the Commission struggles to cope up with the expectations of victims across the country.
And it often finds itself unable to fulfill its mandate of protecting human rights effectively.
Yes.
So, doesn't this inherent reliance on the executive, the very body often accused of violations for staff and for funds, doesn't that fundamentally undermine the Commission's credibility and independence, regardless of the Supreme Court's removal safety net?
That is the structural flaw that needs critical attention. The limitations cited are purely operational and budgetary, but they have existential consequences for the Commission's integrity.
Okay, what are they specifically?
The Commission requires the creation of various posts to effectively discharge its duties, but crucially, there is a systemic shortage of experienced investigating officers.
And these officers have to be provided by the government, meaning the entity being investigated holds the keys to the Commission's effectiveness.
Precisely. The NHRC's most critical investigative functions, conducting spot inquiries on really sensitive issues like custodial deaths, torture, illegal detentions, and extrajudicial killings, they require experienced, dedicated, and impartial staff.
So what happens when the executive fails to provide that staff?
The Commission is reduced to a reactive body. It ends up just documenting violations after the fact, rather than effectively intervening or investigating them robustly. This dependence severely limits its ability to act as an effective check on state power.
So it's a structural bottleneck.
It's an institutional challenge that plagues most statutory and non-constitutional oversight bodies in India.
Let's use this framework of systemic failure to analyze some specific themes that the UPSC favors, starting with the nexus between governance failure, conflict, and human rights. We have a PYQ that asks for an analysis of the impact of non-implementation of the provisions of the Fifth Schedule on the growth of left-wing extremism.
This is a perfect example of a constitutional failure translating into massive human rights violations and internal conflict. The Fifth Schedule, under Article 244, is a protective constitutional mechanism. It's designed to safeguard the interests and autonomy of scheduled areas and scheduled tribes.
So how does the non-implementation of these safeguards translate into a human rights crisis that then fuels LWE?
Well, if we connect this to the bigger picture, non-implementation often results in systemic rights deprivation. These tribal areas are incredibly resource-rich, but the safeguards, which protect against land alienation, mandate consultation on resource extraction, ensure local self-governance, they are often ignored in favor of state or corporate interests.
So when land is illegally acquired or traditional forest rights are denied, these aren't just technical violations, they're violations of Article 21's extended rights to livelihood and dignity.
Precisely. The systemic failure to protect land rights, economic rights, and the cultural autonomy of these populations creates a profound and persistent vacuum of justice. When the state fails to deliver the promised constitutional safeguards, people are stripped of their livelihood. It leads to chronic poverty and exploitation.
And that deprivation is the human rights violation that creates the perfect breeding ground for radicalization.
It fuels extremist movements like LWE. These movements often frame their rebellion as a defense of the very rights the state has failed to protect. So the NHRC's mandate implicitly extends to investigating these large-scale systemic deprivations, even if they originate in administrative failures regarding the fifth schedule.
That analysis really highlights how civil and political rights are so deeply intertwined with socioeconomic rights. Let's pivot to another crucial PYQ area: socioeconomic rights and poverty, linking food security and land reform.
This brings us right back to the tension between fundamental rights, like Article 21, and the directive principles, like Article 47. The PYQ concerning the Food Security Bill and its goal to eliminate hunger and malnutrition. It demonstrates this synthesis perfectly.
So the Food Security Bill, the NFSA, its aim is to achieve the welfare goals set out in DPSP Article 47.
Exactly. By making access to food grains an entitlement for a large portion of the population, the legislature is translating an aspirational DPSP goal into a justiciable legal right.
And since the Supreme Court has already interpreted the right to livelihood and health as integral to Article 21,
the state's failure to implement the food security law efficiently could be argued as a failure to uphold the right to life itself. The NHRC operates within this landscape, sometimes intervening when bureaucratic hurdles or corruption deny these life-sustaining entitlements.
and this emphasis on transformative socioeconomic policy, it extends way back to the history of land reforms. That's the subject of another related PYQ, establishing the relationship between land reforms, agriculture productivity, and the elimination of poverty.
This just shows the foresight of the Constitutional Assembly. Land reform wasn't just an economic measure. It was fundamentally a social justice measure aimed at eliminating entrenched poverty and feudal exploitation, which is a major human rights issue.
And the constitutional framework, you said, actively protected this social restructuring through Article 31A.
It did. The goal was to ensure that the rich and powerful, those whose land was being redistributed, couldn't use their fundamental rights, like the right to equality, to permanently block the poverty-alleviating agenda.
So Article 31A is proof that the foundational documents of the Republic viewed eliminating massive poverty as a human rights imperative.
So critical that it required a temporary suspension of certain other rights in the service of greater social justice. Without land reform, large-scale rural poverty would have persisted, leading to chronic violations of the right to livelihood and dignity for millions.
So the NHRC is one of the institutional tools operating downstream from these profound constitutional commitments, investigating the symptoms of these large, unaddressed inequalities.
That's a great way to put it.
Okay, so we have a comprehensive picture now. The NHRC is a vital statutory watchdog, recently restructured with a 3-year term and expanded SHRC eligibility. It's protected by a judicial check on removal, but it's fundamentally constrained by its reliance on the executive for the resources and staff it needs to investigate the most severe state abuses.
Especially those systemic failures that fuel conflict and perpetuate poverty.
So to synthesize the core elements for you, the learner, the NHRC is essential. It was established in 1993 under the Protection of Human Rights Act. Its current structure, refined by that 2019 amendment, emphasizes flexibility with a 3-year reappointable term.
And it has increased capacity at the state level by expanding SHRC eligibility. Crucially, its security of tenure, guaranteed by that mandatory Supreme Court inquiry for removal due to misbehavior, defines its intended independence.
However, the challenge is always performance versus potential. The NHRC is tasked with tackling issues as severe as custodial torture and illegal detentions, yet its investigative capacity is hobbled by its reliance on the executive for experienced personnel.
Its effectiveness is intrinsically tied to the Supreme Court's robust, expansive interpretation of Article 21, which provides the legal ammunition.
And the political will to realize the socioeconomic goals of the directive principles, which provide the moral mandate.
The discussion of PYQs clearly illustrates that human rights violations in India are often symptomatic of deep structural governance failures, whether it's the non-implementation of the fifth schedule leading to LWE or the failure to adequately address food security, which is an extension of the right to life.
Okay, so let's leave you with the ultimate structural puzzle facing the NHRC. Considering this reliance on the executive, the very branch it's often meant to investigate, for necessary staff and funds, and noting its current statutory limitations, particularly its lack of direct contempt power over government authorities. How might the Indian political system further strengthen its statutory human rights protection mechanism? How do we redesign the NHRC to truly move beyond mere pious aspirations, to borrow that powerful critique and ensure it can autonomously, fiercely, and efficiently tackle urgent issues like custodial violence and systemic deprivations without executive hindrance? That is the question of institutional reform you must mull over.
A provocative and very necessary thought to conclude our deep dive into the intersection of polity and governance.
Thank you so much for joining us for this extensive analysis of the National Human Rights Commission. If this content was useful, please do subscribe to the channel right now, and if you're capable, consider joining the paid membership. Your support is crucial for us to keep bringing you this level of detailed, strategic analysis.
And again, a special shout out and thank you to all of our existing members for helping us keep this mission going strong. We truly appreciate your invaluable patronage.
Don't forget to like this content and share your valuable comments below. A final reminder. Free notes and practice PYQs are waiting for you on our Telegram channel, and premium notes with extra PYQs and model mains answers are available in the Discord channel for our Legend members. Go check them out and keep learning. We'll catch you on the next deep dive.